Hello viewers and students, this is Dr.K Neharkar and I welcome you in my YouTube channel at lecture series on labor laws first. Friends, today we are going to discuss the last chapter from Industrial Dispute Act, that is unfair labor practices. Section 25 and 25U deals with the prohibition of unfair labor practices and the penalties for adopting unfair labor practices. Friends, we must be aware that good industrial relations are very necessary for the development of industry, for the development of employer and employees also. Therefore, it is a responsibility of both parties to maintain good relation, to establish good relation that are worthy for production and running peaceful, smooth industry. So both parties shall not do any act, they shall not commit any act which is going to spoil their relation. Such acts can be any unfair labor practice by the parties. Unfair means which is not fair, which is against the relation, which is against the industry. So friends, we must see what is the meaning of this concept. Friends, unfair is nothing but any practice which violates the directive principles of state policy under Article 43 of Indian Constitution and other articles of Indian Constitution, as well as the provisions relating to payment of wages, working condition, right to trade union, etc. At least the employer shall not violate such laws, such directives which are made for the well-being and welfare of workers. So such activities can be called as unfair activities. Friends, in simple words, the unfair trade practice can be defined as an systematic activity by employer to use his power to disturb the workers, their trade unions, etc. Such acts can be unjust dismissal, unmerited promotions, demotions, partiality, etc. So such practices by employer can be the unfair labor practices on his part. We must see what is the definition of unfair labor practices. This definition is provided in section 2 clause RA of Industrial Dispute Amendment Act 1982. So according to this definition, the unfair labor practice means any unfair labor practices as mentioned under the schedule of the act. So this definition doesn't provide what is unfair labor practice in actual words, but it just makes a reference. It makes a reference towards the schedule which provides list of unfair labor practices that are adopted by employer or employees. Then we must see what is prohibition of unfair labor practices. Section 25T, it works as a prohibition. It means this section prohibits both employer as well as employees. This section prohibits both employer and his trade union or workers and their trade unions from adopting any practices which are not fair. So this is the prohibition. Section 25T prohibits unfair labor practices by employer, workman and their unions. So according to this section, no employer, workman, trade union, whether registered or unregistered, shall commit any unfair labor practices. So this is specific prohibition. They are prohibited from doing any act which is which is termed as unfair labor practice by Industrial Dispute Act. Afterwards we are going to discuss which are those unfair labor practices by employer, employee, etc. But before that we are going to discuss the penalty. Next point we must understand is penalty for unfair labor practices. See, this point there is typing error. The penalty for unfair labor practice, you must read this as penalty for unfair labor practice. Section 25U of the Act prohibits the penalty for unfair labor practice. According to this section, any person who commits unfair labor practice shall be punished with imprisonment up to 6 months or fine up to Rs 1,000 or with both. So friends, section 25T is prohibition for unfair labor practices. Similarly, section 25U provides penalty for unfair labor practices. Now friends, we must see what are those unfair labor practices by the employer. As the schedule of the Act specifically gives a list of unfair labor practices, we are going to see some important unfair labor practices by employer firstly, then we are going to discuss unfair labor practices by employees. So the first unfair labor practice is to interfere with workmen's right to form, organize, join any trade union of their choice. And this is interference by threatening, illegal dismissals, by illegal lockouts or illegal closure, etc. So this is unfair labor practice by employer. Then second unfair labor practice is to dominate the workers and their trade unions, or showing partiality or favor to any trade union. So this is also done to influence the workers. Then next unfair labor practice is to establish employer sponsored trade union. See, it is a responsibility of trade union to look after for the betterment of workers, but when there is any employer sponsored trade union, it may not look into the benefit of employees, but it may take decisions which are supportive to employer. So that should not happen. This is also one kind of unfair labor practice. Then to discharge the membership, to discourage the membership of trade union by discharging, punishing workers by giving them unmerited promotions, demotions, changing the seniority of workmen, etc. This is also the unfair labor practices. Actually, it is right of every workman to join any trade union as per his will and wish, but the employer shall not discourage the membership of any trade union, or employer shall not promote the membership of any particular trade union. This is also one kind of unfair labor practices. Okay. Then another unfair labor practice by employer is to dismiss workmen by way of victimization and not in good faith, or the punishment for false reason or untrue allegation. So victimization is nothing but giving harsh punishment for very trivial or very offense of very less grievance. So for normal offense giving harsh punishment, this is nothing but one kind of victimization. The next unfair labor practice is to abolish the work of regular nature being done by workers and to give it to contractor. So this act is also done by the employer to influence the workers. So when any particular act is done by regular workers, that should not be abolished and that should not be given to contractor, because due to that employees may result surplus, etc. Some problems may arise. Then next, is to abolish the work of a regular nature. The next is mala-fide transfers. So transfer should be made only when it is bona fide for worker, or it should be bona fide for industry. But if that is not bona fide, then it can be called as a mala fide. The real object is to cause trouble or to cause suffer to workmen. The next unfair labor practice by employer is to recruit the workmen in legal strike. As you know, during the period of legal strike, the employer cannot recruit new workmen on the position of workers on strike, but he recruits such workmen, recruits other workmen. Then this is also unfair labor practice. Then next is to failure to implement award. The next unfair labor practice is to deny for collective bargaining, and last unfair labor practice is illegal lockout. So these are the unfair labor practices by employer. Now we must see which are those unfair labor practices by employees. As like the employees may also engage certain practices which are not fair, and these practices are as like: first is to participate or to instigate to participate in an illegal strike. As you know, the strike is illegal when it is commenced in contraventions of section 22, 23 and 24 of Industrial Dispute Act. So when any workman participates or instigates other persons to participate in an illegal strike, it is unfair labor practice. Then second is to coerce workmen to join specific trade union, because it is the freedom of every workman to join any trade union which he thinks fit. He cannot be compelled to join any trade union without his will, without his desire. The next unfair labor practice is to indulge in a picketing or a riotous activities. This is also unfair labor practice by the employees. To refuse for collective bargaining with mala fide intention. So collective bargaining is the method to solve the problem by discussion and negotiation. But when the workers or their trade union deny for collective bargaining process, deny to enter into the process, this is also unfair labor practice. That is not going to strengthen the industrial relation. Then to organize demonstration at the residence of employer and management, because if they want to demonstrate, that should be organized near the industry or within the industry, and it should not suffer the family members of management, owner of industry. Then illegal ghera, it is also one kind of unfair labor practice. Then to cause willful damage to property of employer, this is also unfair labor practice by workers. And lastly, to mishandle the tools and machines. So friends, these are the provisions relating to unfair labor practices. You must understand, you must remember what is concept of unfair labor practices, and then what is prohibition under section 25T. Then you must remember penalty which is provided by section 25U. Then you must remember unfair labor practices by employer and employees. So friends, if you like this video, please share it, comment, and do not forget to subscribe my channel. Thank you friends.